Tararo, who is a police prosecutor with the Cook Islands Police. And I'll just start by saying that I feel a bit uncomfortable being here today because I've only been with the Cook Islands Crown Office for about 9 months. Prior to that, I was a criminal defence lawyer in New Zealand for about 10 years. So I've got a bit of experience working in the sexual and gender-based violence area, but only a little bit of experience as a prosecutor and within the Pacific. So it's been really fascinating for me this week to hear everyone talking about sharing your experiences from your jurisdictions, because it's all very new to me and I've learned a lot. So why am I here? Some of you will know Jamie Crawford, my colleague at the Cook Islands Crown Office, and she's done a lot of work with the advisory panel on putting these regional guidelines together, and more recently starting to pilot them within the Cook Islands. So we're here today to just tell you a bit about what we are doing in the Cook Islands and what we plan to do from here, and hopefully generate some thought and discussion from all of you as we move into working on our own implementation plans for our jurisdictions this afternoon. So I'm very lucky to have Sergeant Tararo here with me today because he brings with him his wealth of knowledge and experience of the Cook Islands criminal justice system, which I am making. So yeah, I'll just hand over to Sergeant to introduce himself.
Kia ora, good morning all. And pula. Just to start, so Jamie was saying we'll be sharing what we plan to do and what we are doing. So I'll be telling you what we're doing at the moment. So I haven't told Lucy that yet. So before I start, I wanted to commend yesterday a friend Fiji came up. He was invited to talk yesterday. I think it's Julene. I should actually be thanking because she's the one that got him to come up. He probably wouldn't have come up otherwise. And to make it even better, Felipe here from Chief Superintendent, he also spoke. So there's a bit of ease now that I'm not the only male that's going to share. Well, I'm not the first at least. So my name is Paul Tararo. My actual middle name is Fairoa, and Cook Islanders actually call me Fai, F-A-I, if you know the insurance in New Zealand. I'm a Cook Islander, and I do have Chinese blood. And I do like, first of all, I do like to put out that I'm a born-again Christian as well, and I'm very much into my spiritual walk. It is the pinnacle scope of my life and my family. So I haven't been asked to pray yet, so I'm still waiting. Maybe I could say the grace, that's a start. So I was born and bred in New Zealand actually. I moved to the Cook Islands and I haven't left. I enjoy it there a lot of there. Great place to bring the children up, by the way. So my role is I head and manage prosecution divisions. More so in the mainland, that's Rarotonga. And Lucy will be sharing about the geography of the Cook Islands. These 15 islands. In the Cook Islands, 13 of them are inhabited with humans, Cook Islanders, and so 12 of them have police officers stationed on each, and they live there as well. So they really are Cook Island. They pretty much are police officers that were already living on the island, so they were appointed and trained into the job. One thing they don't have though is they're not trained prosecutors, and I will elaborate a bit more on that. In the Cook Island Police Force, there's 105 police staff, 88 sworn officers or around about 80. We tend to lose, we're actually losing quite a bit. Better life overseas. Prosecution sees 4 now in my office. There's about 20 CIB, 20, just over 20 prevention, and that includes the outer islands police officers. And then you've got the maritime police, and most of our sworn officers are frontline general policing. I said that I manage the prosecution branch, but I also still prosecute. In fact, I prosecute more than any other prosecutor in terms of the police. And the only time I'm not prosecuting is when I go overseas, so thank you, PILON. And so besides my direct boss, which is the Deputy Commissioner of Cook Island Police, I say that I'm probably the hardest worker in the Cook Island Police Service. And I can say that because I don't know you guys. And I say this also, I also say this because this word I picked up yesterday, I may have read it, I may have not, but I definitely understood it yesterday. That was a result of the Dr. Julia Ioane. I'm not sure if she's here. Oh, she's there, okay. But I actually wanted to compliment how great her presentation was yesterday. But she said the word grandiosity. I don't know, maybe you guys know what that word is, of course you do. I'm not, so I kind of looked it up a bit as well last night, and I realised that I'm not the only one in our office, and I'm not the only one in the Cook Island Police. So I tend to think that if I do the job, it can be done better. But yeah, I suppose delegation helps, and not to think that I'm alone at it. So, and it's quite it's a humbling word as well for me. It was humbling to just hearing it yesterday. So our branch deals with all cases, and even the more serious cases. Jamie will say they handle all the serious cases, and she's right. We do handle up to a point the serious cases as well, and the lower cases. So we can handle the serious cases by way of bail applications, and then it gets transferred to the Crown Law, Jamie and Lucy. And in terms of judge matters like trials and so forth, it's all Crown, thankfully. We do also prosecute for the outer islands as well. As you heard me mention, our prosecutions, our outer islands police officers are not trained prosecutors except Otitaki. You may know Otitaki, it's one of the most sorted places for a vacation or holiday. But they have their own prosecutors on the island, and they are trained pretty much. But we still overlook it and get advice, and likewise with Crown. Because of the resource constraints as well, we do most of our we have been doing most of our cases via Zoom. So good technology at the moment. Each outer island has their own DRs, deputy registers, so it's good also because they can set up Zoom, and we would have the JPs and the judges sit in the courts in Rotorua, likewise with the prosecutions, police and the Crown, and we'll be zoomed out to the outer islands. So there's not really many cases in the outer islands. If there are, it's usually serious cases. And once again, with the resource constraints of that, but we're pretty much obligated to get some CIB officers out there to investigate cases. And in sexual cases, offences and that, we will most likely bring the offender in and deal with them in our time, likewise with serious assaults and that. Excuse me. Okay, we have a two-tier judicial system. We have the lower courts and the high courts. We have the lower courts, which is usually run by the JP, the Justice of Peace. Justice of Peace are a politically appointed position, and they do get, there are lawyers, or a lawyer, that's a JP as well, ex-Solicitor General as well. So it's good we get that wealth of knowledge and experience on that sort of thing. So the JPs they're trained like police officers, and the High Court is usually the judge, and all our criminal judges are from New Zealand. I think there's 4 or 5 of them, if I'm correct. And so we would have the judges come in a year, minimum or maximum of 3 jury trials a year. And in fact, we've got one running now, and our CJ is running that now. So I was just talking to Jamie about our case today. I won't tell you the results. But anyways, the Justice of Peace have a jurisdiction where they can hear cases up to 3 years imprisonment, but they can only imprison a person up to 2 years max. And likewise, the 3 Justice of Peace panel, and they will hear cases up to 5 years, with the exception of a burglary, which is 10 years. Otherwise, all cases 7 years and up are judgments. Our JPs does have a lot of powers, but they're still guided by our Chief Justice. And just to elaborate on that in terms of our SGBV. So for a bit of stats for 2023, we had domestic violence offences, family violence report. We had 57 charges laid for that year, and sexual we had 13. And JPs handle 78% of those cases, and mostly the domestic or family violence. And the judges most definitely will handle the sexual offences, and they would run 22% of our SGBV. We do collect data in our prosecution division, and so the data is done on a monthly basis, and this data is also provided to the staff, especially the executives. Our intelligence officers are actually the ones that are supposed to be collecting these data, but they're very understaffed at the moment, and we do it just to assist as well. So, and we've also taken up a lot of other departments' duties as well. So, but for the sake of the Department of Police, it's not about our mission or that sort of thing. So the best practice process. Okay, so I'm just going to discuss a bit about our manual that was introduced in 2008. In fact, it's the New Zealand Police that drafted it for us. At the time, we had the ex-New Zealand Police Commissioner. It was the manual best practice for family violence 2008, and the best practice process for responding to the domestic violence incidents. So the whole focus and aim to effectively apply a whole of policing approach in reducing our family violence in the Cook Islands. So it comes with quality investigations, which are essential for effective resolutions in cases of domestic violence, and ensuring that the victim's safety and the offender's accountability are the driving force of the best practice of the manual. It is essential that all police officers carry out their respective tasks in order to achieve this. We have the no-drop policy. Once again, it was introduced by the New Zealand Police. It's funny because I don't think they actually had the the no-drop policy in the New Zealand Police, but no, not anymore. Anyways, I think Fiji explained it well yesterday, what the no-drop policy is. Once it's reported, we must investigate. Okay, we must, it's a must. And then once the charges are confirmed or there's evidence, the charges must be laid. That's what the no-drop policy is. Courts have misinterpreted it, where it's gone to court and they think, oh, the police can't drop the charges, thinking that in the courts, but it's not the case. But further to that, so where victims recount or request that the charges be withdrawn, this can only occur with the express written permission of the Commissioner. So such permission will only be given in rare and compelling circumstances. Please don't ask me what those are. But where domestic violence criminal offences are substantiated against police officers, so these are just charges where the police is involved, they too will be kind of follow the same process and it's not withdrawn. Investigators will remove the responsibility for prosecutions from the victim. We do not have the witness or victim support officer. And just to elaborate more on that, the officer in charge, besides the prosecution, pretty much does everything from the start to the end. Officer in charge. So prosecution will get involved, but that's usually for trial cases and that sort of thing to make sure it's all done. So the emphasis will be placed on a successfully prosecuted domestic violence offence. This will require investigation practices. I'm actually just reading a bit from the manual. This will require investigation practices that rely on evidence gathering at the scene and not on the victim's evidence. So, so we don't, I mean, if the victim gives us a statement, we got the medical, we've got the photographs, and she refuses to give evidence in court, we'll still proceed to some extent. We will still proceed with the case. We'll just throw it before the JPs or maybe the judge as well, and let them decide pretty much. But our Evidence Act is put in a way where married couples are not compelled to testify against each other. But yeah, that's hopefully going to change. Yes, so as I said earlier on, the witness and we don't have the support officers. It's something we definitely need, I reckon, and Lucy and I were discussing how we go about it and probably get it into our prevention division to at least to kickstart it. You may know who Rebecca Alice Hosking is. She's back with the police now, which is good. We definitely needed her. She's our domestic violence coordinator. So if I did come, she would come. Okay, so what is there for the victims? So as you heard me yesterday, it's a legal requirement that we contact the social maternal affairs welfare officers to advise them that a child has been involved in assault or sexual matter. So they pretty much turn up and they kind of just take over in terms of the well-being of the child, the welfare, and and they do well for what they do. So Opunama Tauturu was incorporated in 1994. This is a women's counselling centre provided for women, and they do also help for the men as well. They are victims of certain cases. And they determine, so they make decisions about, so the support environment for women is to make decisions about themselves and to determine their future when they become victims of violence and sexual assaults. So they provide counselling. They also provide safe houses, and that's usually, there's no actual place for safe house. It's most likely they'll look for other family members to take them in and so forth. And that's exactly what the internal affairs does as well. And they have actually just been funded recently, so we expect to see more of them around and to justify the existence. Education also has New Zealand ex-New Zealand social workers. They're very active, they're really out there, so we do use them a lot as well, especially with the young children. And also for counselling or for victims, a lot in the Cook Islands resort to spiritual counselling, pastors and that as well. So there's that sort of avenue they choose. So those are the NGOs and where there's a whole lot more. So we've got a whole lot more counsellors and organisations and NGOs and that they can help out as well. And the victims will pretty much be put in place as the cases go through. I have so much more, but I'm going to end here. And I'm going to hand it over to Lucy, and she can answer all the questions as well.
Yeah, I would agree with Paul that he's the hardest working police officer within the Crown Police. If we ever have a question on any police file, it's just I'll bring Fai, ask Fai, and he seems to be across every single file that the police have. So yeah, he is one of our superstars. So yeah, the Cook Islands, we talked a bit about this. Our population is around 17,000, so we're not the smallest jurisdiction here. I think that might go to our friends in UA, but we're one of the smaller ones. Population of Rarotonga is about 10,000, so the bulk of the population is on Rarotonga, but we need to be mindful not to forget about the rest of our population on the outer islands as well. Our exclusive economic zone is almost 2 million square kilometres, but the landmass of all of the Cook Islands is only just over 200 square kilometres. So yeah, very small country, but covering a really large geographical area, which does pose its challenges in terms of accessibility, particularly to the northern route. Flights there are very irregular and expensive as well. So yeah, we are a self-governing country in free association with New Zealand. Prior to 1965, New Zealand made all our laws. We now make our own laws, but with the continued assistance of the New Zealand Parliamentary Council Office, who help us with our legislative drafting, and I understand that's the situation for UA and Tokala as well. Our legislation is very heavily based on New Zealand legislation, but it hasn't quite kept up. For example, our Evidence Act, and you've already heard a bit about a provision in our Evidence Act, but it's dated 1968, and there really hasn't been any significant amendments to it since then. But we are really lucky in that all of our judges come from New Zealand. So in terms of things like special measures applications, they are well versed in those kinds of procedures that are now very routine in New Zealand trials. So even though our legislation doesn't explicitly provide for special measures, it is the judges have a very broad inherent jurisdiction, and they're very prepared to use it to implement those measures that are so important in these kinds of trials. What's next? So I think we've already heard a bit about this and the way our criminal justice system works. Just with my office, the Crown Law Office, I've discovered from being here this week that we are, it seems a bit of an outlier in that we're not a prosecution's office. Our office provides advice to all government departments across government. So prosecution, criminal prosecution is a very important part of what we do, but it's definitely not the only thing we do. Our office currently has, I think 7 lawyers, including our Solicitor General, but there's really only 2 of us doing criminal prosecution because there's only 2 of us who have any prior experience working in criminal law. So, and we are of course also expected to do a whole lot of other random stuff as well as the criminal stuff. So lots of competing priorities. And yeah, another kind of challenge we have within our office is that most of our lawyers are on short-term contracts of 2 or 3 years, mostly from New Zealand. And that's the same for the Solicitor General role as well. Generally, it's held by someone who is not a Cook Islander, and generally held by someone on a short-term contract. So there is a really high staff turnover. There's that lack of institutional knowledge that comes with that, and the difficulties with being able to really implement things well when you don't have those solid people that you know are going to be there and be able to see it right through. So that's a real challenge for us, and it's something that we've really had to look at in terms of our implementation and what we're hoping to do. So yeah, I think I've already talked about most of this. We have limited resources, but I know that's the same with everyone. We don't have a witness support officer. So it's really, in terms of our implementation, we're really focused at this stage on just working with what we've got and how we can improve our current processes to better support victims at this stage. Hopefully sometime in the future we will reach a stage where we will have a witness support officer role established, because it's something that being here this week is just, yeah, you can see the benefits across so many different, throughout the process. So yeah, hopefully that's something that will happen in the compliance at some stage, but in terms of implementation at this stage, we're looking at what we can do now without that role being in place. So I'm not really expecting anyone to participate here, but if anyone did feel like sharing at this stage what they think their challenges are in their jurisdiction, it's something that everyone's going to be talking about within our groups this afternoon. But yeah, I know Fiji, for example, yesterday it was really interesting to hear that you guys have your own guidelines already, but what you thought was lacking was that witness vulnerability risk assessment. So I thought that was really cool how you had identified that gap and seen how the guidelines could really help fill that gap. So yeah, does anyone feel like sharing it at the moment?
Sorry, I should probably just clarify. So we have guidelines specifically for children. We don't have guidelines for overall like victims and witnesses. So we'll definitely be using these guidelines to help us draft that. But I just want to clarify, sorry. So we have guidelines for dealing with child witnesses, not the rest of the population.
So yeah, I just thought I'd chuck up some of our stats. So these are quite old stats, but I think they're still a good indication of where the violence is at. So this was a 2014 study undertaken by our Ministry of Health to my order. So around 30% of ever partnered women had experienced physical and or sexual violence by an intimate partner. Around 13% had experienced sexual partner violence. And of those who had experienced physical and or sexual partner violence, 30% had never told anyone about the violence. So obviously an issue that needs to be addressed. And I just thought this was quite an interesting graphic. This is from the UN Population Fund of women who experience intimate partner violence across Asia Pacific. And I just thought it was quite good to highlight a couple of things. One is that it's very clear that there's no countries up there that don't have a problem with sexual and gender-based violence. But also just illustrating that everyone's different and we're all going to have our own challenges. Everyone's different not only in terms of our statistics, but in terms of our social context, our legislative context, and our political context. So what implementation is going to look like for everyone is going to look pretty different. So how have we started to implement the regional guidelines? Our implementation at this stage, there's nothing kind of in writing, there's nothing, we haven't got any written guidelines in place, but really it's been a matter of every sexual gender-based violence file we get, when we get it, looking at it and just turning our mind to the principles and the guidelines and how we can use those principles and how we address each file from the outset. So within our office, we've really tried to start earlier engagement with our witnesses, which we've heard this week. The early engagement is important. So yeah, an earlier referral of files from the police as well. Having just one prosecutor carrying the file from start to finish, if at all possible, because the last thing we want is to establish rapport with a vulnerable witness and for them to put their trust in us, only for it to be handed over to someone else at some stage down the track. So being really mindful of that. Special measures applications, like I've talked about, we are making. The judges are very happy to grant those applications. They're not generally opposed by Defence Counsel. So special measures that we would be using would include giving evidence remotely, or screens, support persons, closed court, name suppression, stuff that we've already heard is being done in other jurisdictions as well. You've heard about the no drop policy, and I think that might come up on a slide in a second. So yeah, our no drop policy, similar to our friend from Fiji yesterday, the matter's going to be investigated, the charges are going to be laid, but it's not a policy that we've got to take the prosecution right through to the end, no matter what. If it gets to the prosecutor and the evidence isn't there, or there's other, it doesn't meet our evidentiary or public interest considerations and whether to continue the prosecution. Just on that, we don't have any guidelines within our office, any prosecutors' guidelines, but we do refer to the New Zealand Solicitor General's prosecution guidelines as a really helpful tool for assessing evidentiary considerations, public interest considerations in terms of continuing with prosecutions, in terms of resolution discussions. Even though they don't apply in the Cook Islands, they're a really useful tool, and I refer to them all the time. And we've been doing some police training as well. One of our issues with this, more with our frontline staff responding to the domestic violence stuff as opposed to the more serious sexual offending. Often matters get to trial and the initial statements, the initial evidence gathering is not great. So we've really tried to put some effort into doing some training with the frontline police about that evidence gathering at the outset, the importance of getting that evidence early, not only for evidentiary purposes down the track, but to get a really good statement from the victim at the outset, so that we don't have to be going back to them, trying to take further statements from them, and obviously putting them in a situation where they may be triggered or re-traumatised. So this is the Cook Islands Police no drop policy from the manual, 2008 manual that Paul has talked about. Investigations will not be dropped, charges will not be dropped, and it will only, where a victim recants or requests that charges be withdrawn, this will not occur without the express written permission of the Commissioner. And then here as well, investigators will remove the responsibility for prosecution from the victim, which I think is really important. So it makes it really clear that the victim is not, we're not representing the victim, we're representing the state, and our job is to hold offenders accountable. So most of that is actually on sufficient evidence gathering, because we know that victims will recant, seek to withdraw the charge. This is normal. So what have we done at that initial evidence gathering stage to make sure that we've got any other evidence that we can get? Evidence from other people who were there, medical evidence, photographs, etc. And then this is just a slide that I took out of the training that our office did with the frontline police staff about responding to domestic violence incidents. Record everything in your notebook, something that I think needs to be hammered into our frontline police. Considerations, is this the best environment to be taking this statement, or are there other safety considerations that we need to address first? Where is the accused? Does she need to see a doctor? Is she in too much of a state at the moment to make a statement? So it's okay to get a statement from the victim the next day, but when we do take the statement, they need to give their best account of what happened, do it once and do it right. And two reasons for this. One, again, is for the evidentiary process. When we get to court, we need to have that, we need to have the best evidence there, but also, the victim-centred considerations as well. Don't be focused on taking a statement when there are more important things that you need to be addressing first. Okay, so this is our implementation plan. I don't know if you can read it, but I think there might be copies that are being distributed. And I'm by no means saying that we are experts at creating implementation plans, or that this is the right way to do it, or the best way to do it, because we're here learning about implementation just like everyone else. And this was created before we came, and throughout the last 2 days we've been having lots of discussions about how we can implement what we've been learning this week when we go back to the pilots. But anyway, we've set ourselves 2 goals. One is to reduce harm and trauma to our witnesses, and the second goal is to increase our conviction rates for SGBV offending. And the hope is that goal 1 will lead into goal 2 by better supporting our witnesses to give their best evidence. We will have more prospects of conviction at the end of trial, and hopefully in the long term create more public and societal trust in the criminal justice system when it comes to this type of offending, because our stats show that quite a high percentage of those who have experienced violence within our community haven't reported it. So that's something that we want to address as well. So one of our actions in implementing, in reaching our goals, is to adopt the templates from the regional guidelines. And the great thing about the templates is that all the hard work has been done for us, and it's not going to take much to put those, to chuck those on the front of our file and start using them. They're really user-friendly. I think they'll be really easy to adapt, particularly in our jurisdiction. And by using them, it's forcing us to turn our minds to all of these issues right at the outset. Because, when you receive a new file, what else is on your desk? bail application. What else? We've always got a lot going on. So to force us to sit down and do this vulnerability assessment, it forces us to read the file carefully, to turn our minds to all of these issues, and that will help us to better support our witnesses right from the get-go. Creating a uniform internal procedure. We don't have any kind of guidelines or procedures around how we deal with our files. So what that means is that there's the potential for not every file and not every victim to be dealt with in the same way. So the templates will form an important part of our procedure, but I think also just making sure that there is a standard procedure for when we receive these files, for what needs to happen on them and whose responsibility it is and at what stage of the process, so that we know what needs to be done, and we can make sure that hopefully people don't slip through the cracks. Creating template court documents for special measures applications is something that I think will be really useful within our office, particularly because we've got staff coming and going. For there to be a central place where you can find easy to use, easy to access templates for any special measures application that you might need to make. I know that would be really helpful for me, so I think that's something that I can do without too much effort. That will then be a really good resource for any other lawyers that take on prosecution of this kind of offending. And then of course training, and we've heard this week about the importance of ongoing training. You can't just train, do a PowerPoint presentation once and then send everyone on their way to do what you told them to do for the rest of their career. So yeah, just the ongoing training, the ongoing bringing everyone's mind back to what we need to be doing, and reflecting on how we're doing and in what ways we can do it better. And then engaging with our external stakeholders is going to be really important in terms of referrals for witnesses, and particularly where we don't have a witness support officer. That's going to fall on the police and our office to make sure that the witnesses are supported properly from the outset and with whatever the support they need throughout the process. Our second goal to increase the conviction rate, our actions for that goal are pretty similar to the first goal. There's the addition of engaging with the Ministry of Justice for buy-in with prioritisation of our cases. Our judges are pretty good at that anyway. I'm not sure, potentially there's a bit more work to be done in the Justice of the Peace jurisdiction, but definitely there's benefits in that being an ongoing conversation as well. And then our data collection. I know within our office, our data collection is very poor. And working with the police, because the police are collecting data, so it could just be a simple case of us sharing that data and us adding to that data with the files that we're working on. So turning our minds to it, because one of the issues is that we're all just so busy doing our job that where do we find the time to do all this stuff? So kind of recognising that and making the time to do it, because once we make the time to do it, it's going to make our job a lot easier. So it's worth it. I just thought we did think about whether to include in our implementation plan the establishment of a witness support officer role, but our reality is that that's a decision that is outside of our control. Most definitely we can go back to the Cook Islands and advocate for it and push for it, and hope that at some stage it will be established. But in our implementation, we just thought, well, it's probably better to focus it on this stage on things that we know we can do, rather than things that might just be aspirational at this stage. So that's why it's not part of our implementation plan, but it's just meant that we've had to do a bit more thinking about how our witnesses can be supported without that witness support officer. And like you've heard, it's a role that is for the most part played by the officer in charge and the prosecutor, but generally the prosecutor wouldn't come in until a much later stage. So what we're trying to do is bring that involvement forward, so that the prosecutor is involved from the outset. But I thought I'd just share a bit of an anecdote with you about how this might not have worked very well. So a few weeks ago, our office became involved really early on with a prosecution of quite serious family violence offending. And my colleague had a really early meeting, sit down, meet and greet with the victim, talked about bail decisions, the defendant was granted bail conditions, and advising her of the outcome of that bail application. A couple of weeks later, my colleague got an email from the victim, first of all thanking her for representing her, but then also wanting to go into a discussion about her evidence and her statement that she had given to the police. And so we kind of made us stop and think, well, she had to go back to her and say, well, actually I don't represent you, and it's not appropriate for us to be liaising about your evidence. So it made us stop and think about, oh well, is there something that we could have done when we had that initial meeting with her to avoid that situation and that misunderstanding happening. So it's a real learning process for us. But yeah, I mean, those are the kinds of situations that you do learn from. And yeah, so in terms of supporting our witnesses, yeah, we're wanting to bring the prosecutor on board earlier. The officer in charge is still going to play a large role in supporting the witness throughout the process. Engaging with our external supports is going to be important as well. And particularly, we've just got a couple of new counsellors in Rarotonga that are employed by the Ministry of Education, but they're very experienced. They work with young people, both victims and young offenders. So I think that they would be a really good resource for us to tap into in terms of supporting our young witnesses anyway. So we've got some work to do, but we know what we need to do, which is the first step. And so our next steps are putting in place those processes, using the templates, stakeholder engagement, and I think the buy-in thing is not just relevant for like external stakeholders, but also within our organisations, because we've got other jobs to do. So we really do need our employers' support to put time and energy into our implementation. So that's a really important conversation for us to have, I think, as well. Lots of training, ongoing training, and then of course looking at how we go in and reflecting on how we're doing and what we could potentially do better. So that brings me to the end of our presentation. Is there anything else that you would like to add? No?
This one might have been for earlier.
So psychological support, we do have one psychologist on the island, sometimes two, I think. So they're employed by our Ministry of Health. We don't have like mental health crisis teams. We don't have a lot of resources. So psychological support, is potentially going to be dealt with by just a general practitioner with hopefully a quick referral to a psychologist if needed. Yes. Yeah. I think probably more of a focus on the witness support side of things is probably how we can looking at how we can do some more work on addressing that side of it. I think. What do you think? Yeah.
The question is,
The question was, is
President, but the successful of the entry management training, you can tell from experience that most of the criminals they don't think deeper what the consequences of their doing or their action. But when they sit down, learn about the reality of life, it makes a change to calm down their mind, their way of life. That's why they end up with some very serious condition of violence against their, especially their nuclear family members. But once they sit in this program, so this program was free offered by the Salvation Army for anyone who would like to join in the program. So most of those people that go through this process, it's hard for us to see that they go again with the same issue. That's how it's successful and effective. Another part of the process is really inclusion in the condition of the ruling after the proceedings sometimes. Such as direct referral of the perpetrators to seek the same program. So, and that's a result of close working with partner agencies, such as the Salvation Army. Not only that, but women and children crisis center, Safe House, the psychological unit of the Ministry of Health, and not only that, there's a change program, a lifeline. We work together before any proceedings. So they all offer this program. And it's up for the criminals to choose whatever problem they like to say that, and that's how it's effective. It's improved a lot of on their lifestyle. That's all I can say. I think I answered your question. Now,
Thank you for that contribution to our many questions and answers. We have one more question that's addressed to Paul from the last presentation. You mentioned that in your legislations, couples are compelled to testify against each other. What happens if there's a domestic violence case or an assault by a husband to his wife or partner?
I'm just going to say from experience, I've had, I think fortunately it wasn't a serious assault where the legislation was used by the Defence Counsel. And then you've got, I did mention that besides what the victim, I think it comes back to the guidelines where we don't heavily rely on the victim's evidence herself. So we do resort to other evidence, which is the medical report, the photographs, and any other of these evidences. We will still push for it, even though the victim hasn't they're not compelled to testify against each other. But Defence Counsels are always making applications that they want to cross-examine the victim and all those sort of things. So it's obviously an ongoing thing, but we will still proceed with the case based on other evidence rather than relying on the victim testifying. But obviously it has to be a really, the photographs are showing the injuries are there, medical report from the doctors, and the doctor gives that evidence report. We still go with it.
Thank you very much for that answer. Any other questions?